Hi, my name is Dave McKinley, and I'm here to talk about provisional patent applications. In order to do that, though, I think I need to start with a brief introduction to patent law. I'm going to be using some terms that we need to define before I can dive into provisional patent applications. Patent laws started in our country with the Federal Patent Act of 1790. There were other kinds of patent laws before then, but in 1790, Congress was granted the power to pass the Federal Patent Statute by Article 1, Section 8 of the Constitution, which was adopted on September 17, 1787, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Earlier forms of patents date all the way back to medieval times in 1331. A patent is a deal that you make with the government. You agree to teach your invention to one skilled in the art, and in exchange, the government grants you a 20-year monopoly. And what this 20-year monopoly does is it allows you to recover your R&D investment, and it also provides you an opportunity to make money as an incentive for contributing to the inventive arts. As of 1995, the term of a patent became 20 years from the earliest filing date of the application. The extent of the rights of a patent are determined by the wording of the numbered claims at the end of the patent, as interpreted in light of the description of the invention. Requirements for a patent include novelty, which means that nobody else has already filed for an application to the same invention, and it has not been published in a document anywhere. The second requirement is that it's non-obvious. In other words, it's not an obvious improvement in the development of an idea that is already known, nor is it an obvious combination of two or more other inventions. And the standard for this is as examined by one skilled in the art. So in other words, if you have a dental invention, it can't be obvious to a dentist. And whether or not your claims are patentable is determined through the examination process by a patent examiner at the United States Patent and Trademark Office. So having established that, now I think we can dive into provisional patent applications. These, in a word, are just simply placeholders. They establish a filing date for your invention. We talked about how a patent term extends 20 years after the earliest filing date, but in the case of a provisional patent application, that first year does not count against the patent term. However, it does expire after 1 year, so you have to file a formal utility patent application within 1 year of filing the provisional patent application if you want to claim priority to it. The requirements of a provisional patent application are relatively simple. You just need a description and you need drawings where it's necessary to understand the invention. However, this description is really setting out what you can claim priority to, so you want to be as complete as possible. Advantages of filing a provisional patent application are, first, they're very easy to prepare. There's no formal requirements other than conveying the invention. Inventor notes are often great for this, especially if they include drawings. And the claims at the end of the application are not needed in a provisional patent application, and those claims are difficult to write, so that's where you're going to want to hire a skilled patent attorney or patent agent to help you out, but not needed for a provisional patent application. They're also very inexpensive. The provisional application fee for a small entity, which is any entity under 500 employees, is only $140. Once you file a provisional patent application, you can mark the item patent pending. This allows you to start marketing your idea. There are a few strategies that we recommend when it comes to filing provisional patent applications. The first is to make the description as complete as possible. I've kind of covered this. Use drawings. Drawings are worth 1,000 words, and in the world of patent law, they're probably worth quite a few more than that. There's a lot of information conveyed in a drawing that you would not think to write down. So drawings fill in a lot of the blanks for descriptions. File early and often. You can file multiple provisionals and claim priority to all of them when you file your non-provisional patent application. So the way this looks is you have an idea, you brainstorm, write up as complete a description as you can, and file a provisional patent application. 2 weeks later, you're working on your idea. Things change a little bit, you have more ideas. You can just tack on more description to that original provisional application and file it again. Do that as many times as you want, and within a year of the earliest one, you can file a utility or a non-provisional application that claims priority to that earliest one. We also recommend that you use a patent firm. This is not mandatory, but you do need to think about that 1 year deadline, and if you use a patent firm, you'll be in their docketing system and they will remind you. So how do you file a provisional patent application? There's a few different options. I've mentioned using patent lawyers. Patent lawyers must be registered to practice before the USPTO. Don't call a non-patent attorney and ask them to file a patent application for you, as they will tell you they're not registered with the USPTO. A patent attorney shouldn't charge you very much to file a provisional unless you're asking them to help you with drafting the disclosure. That's when their hourly rate's going to kick in, and it'll get more expensive. Provisional application fee, like I said, is only $140. Another option is to use a patent agent. Patent agents are different from patent lawyers because they basically are patent lawyers are patent agents that have been to law school. Patent agents must be registered to practice before the USPTO. They cannot give legal advice because they're not lawyers, but they are generally less expensive than patent attorneys, so they're advantageous that way. And we have a patent agent working at our firm. Another way to do it is to file it yourself. This is a little dangerous because you have to remember to track that deadline. And you're going to want to hire a patent attorney or a patent agent well ahead of the deadline to file that non-provisional application. They'll need time to draft it up and review it with you. So mark on your calendar a couple months ahead of the deadline that it's time to start looking for a patent attorney. There are books available to help you do this, and the USPTO also has a helpline for this. Finally, there are patent assistance companies out there. I hesitate to even list this as one of the ways to file a patent application. You've seen these on late night commercials. They're very expensive, and basically what they'll do is they'll do a search and find information on the internet that's free that you could have found yourself, and they'll throw it in a binder with a pretty bow on it with your name on it and make it look very official. But when it comes time to filing an actual application, a lot of times they will have to refer you to a patent attorney. So a lot of them are scams. I'm not saying all of them are, but just buyer beware when it comes to the patent assistance firms. Thank you for your time. This has been Provisional Patent Applications. I'm Dave McKinley from Inskeep IP Group.